In 2025, the UK Parliament passed Renters' Rights Act, which is the biggest shake-up to renting in decades, affecting 11 million renters and over 2 million landlords. Today, I'm breaking down exactly what's changing, why it matters, and how it will impact you. Whether you're a renter, a landlord, or just someone trying to understand the biggest housing reform in a generation, this video is for you. Why this law exists. For years, renters across England have been raising the same complaints: sudden evictions, unpredictable rent hikes, damp and mold that never gets fixed, and landlords who could remove tenants with almost no accountability. Under the old system, millions of people lived with the constant fear that a Section 21 notice could appear at any time, 2 months' notice, no explanation, and you were out. That insecurity affected everything: work, school, childcare, mental health, and the ability to plan for the future. And fixed-term contracts didn't help. If your home was cold, damp, unsafe, or poorly maintained, you were still locked in. Although landlords still had the obligations to ensure that their property was fit to live in, the process of ensuring compliance was difficult and slow, and you often had to keep paying rent, even if the property wasn't fit to live in. The government promised to transform the experience of private renting. And in 2025, they finally delivered. But this act is bigger than headlines suggest. It doesn't just end no-fault evictions, it rewrites the rules on pets, health and safety, eviction grounds, notice periods, rent increases, and transparency across the entire sector. This is a complete redesign of renting in England. The end of Section 21. Let's start with the headline change. Section 21 no-fault evictions are gone. For decades, landlords could evict tenants without giving a reason. 2 months' notice, and that was it. No explanation, no accountability. But under the Renters' Rights Act, that era is over. Here's what changes. Landlords must now have a valid legal reason to evict. All evictions must go through a strengthened Section 8 system. Tenants can no longer be removed simply because the landlord feels like it. Courts will require evidence, not assumptions. This is one of the biggest shifts in UK housing law. Renters finally gain real security. And to prevent abuse, tenants get a 12-month protected period at the start of every tenancy. During that time, landlords cannot evict to sell or move in. This gives renters stability from day one. Goodbye fixed-term contracts. The classic 6-month or 12-month tenancy is now gone. All tenancies become rolling periodic agreements. Usually month to month. Here's what that means. No more being locked into a bad property. No more paying rent for a home that's unsafe or poorly maintained. Tenants can leave with 2 months' notice. Landlords must use Section 8 grounds if they want possession. This gives renters flexibility, and forces landlords to follow strict legal processes. And for clarity, long leases over 21 years, like shared ownership, are removed from the assured tenancy system entirely. Pets. A brand new right. One of the most talked about changes, tenants now have a legal right to request a pet, and landlords cannot unreasonably refuse. Here's how it works. Tenants can formally request a pet. Landlords must respond within 42 days. Refusals must be reasonable and evidence-based. Landlords may require pet insurance. Blanket no pets policies are effectively dead. For millions of renters, especially families, this is life-changing. Awaab's Law, Health and Safety. Awaab's Law, named after 2-year-old Awaab Ishaq, who tragically died from mold exposure, is being extended into the private rented sector. This means landlords must investigate hazards within strict time limits. Repairs must begin within a legally defined time frame. Damp and mold complaints cannot be ignored. Failure to act can lead to enforcement or ombudsman action. For renters living with unsafe conditions, this is a major protection. And it's backed by the Decent Homes Standard, which will apply to private rentals for the first time. Rent increases, new rules. Rent increases now follow a formal statutory process. Here's what tenants can do. Challenge increases. Take disputes to tribunal. Demand justification based on market evidence. And the tribunal system is being reformed to protect tenants. Key changes. The tribunal can no longer raise rent above what the landlord proposed. Rent increases can't be backdated. In cases of hardship, increases can be deferred by up to 2 months. No more sudden, unexplained rent hikes designed to push tenants out. New Section 8 grounds. With Section 21 gone, Section 8 becomes the backbone of eviction law, and it has been completely overhauled. Major grounds now include: landlord intends to sell. Landlord or close family member wants to move in. Serious rent arrears. Antisocial behavior. Breach of tenancy terms. Repeated late rent. And the rules are stricter. For example, selling or moving in cannot be used in the first 12 months. Tenants get 4 months' notice for these grounds. Landlords cannot re-let or market the property for 12 months after using these grounds. This prevents abuse and protects tenants from being misled. Notice periods. 4-month notice. Selling. Landlord moving in. Redevelopment. 2-month notice. Mandatory grounds. Ground 5. Ministers of religion property held for use by a minister of religion and required for that purpose. Ground 5A, agricultural worker accommodation landlord needs the property for an agricultural worker. Ground 5B, employment-linked accommodation, PRS provider, tenant no longer meets employment-related eligibility requirements. Ground 5C, end of employment by the landlord expanded former Ground 16. Employment has ended or property needed for a new employee. Ground 5D. End of employment requirements, PRS provider, tenant no longer meets employment criteria included in the tenancy. Ground 5H, stepping stone accommodation tenant no longer meets eligibility criteria for transitional/stepping stone housing. Discretionary grounds. Ground 9, suitable alternative accommodation landlord can offer suitable alternative accommodation. 4-week notice. Serious arrears, 3+ months. Repeated late rent. Breach of tenancy. Immediate or short notice. Serious antisocial behavior. Criminal activity. Severe property damage. Tenant notice. 2 months to leave, anytime. These timelines are legally binding, landlords cannot shorten them. The Landlord Ombudsman. Every landlord must join a new mandatory ombudsman. Tenants gain. Free dispute resolution. Binding decisions. Compensation where appropriate. A route to challenge poor treatment without going to court. This is one of the strongest accountability mechanisms ever introduced. And landlords who fail to join the Ombudsman will not be able to use certain possession grounds. National Landlord Database. Every landlord. Every property. Every compliance record, all in one national database. Tenants can check who owns the property, whether the landlord is registered, whether there are outstanding issues. This brings transparency to a sector that has historically operated in the shadows. And it helps councils target enforcement where it's needed most. Timeline. Phase 1, May 2026. Tenancy reforms. End of Section 21. Rolling periodic tenancies. Phase 2, late 2026. Landlord Ombudsman. PRS database. Phase 3, TBC. Decent Homes Standard. AWAB's law extensions. This is a multi-year rollout, not an overnight change. What this means for renters. Renters gain. Protection from unfair eviction. The right to request pets. Clear notice periods. Stronger repair rights. The ability to challenge rent increases. Access to an ombudsman. This is the strongest set of renter protections England has ever seen. What this means for landlords. Landlords must follow stricter eviction rules. Register properties. Comply with Awab's law. Justify rent increases. Respond to pet requests. Meet higher property standards. The sector becomes more regulated, but also more professional. Real-world scenarios. Scenario 1, landlord wants to sell, they must give 4 months notice and cannot re-let for 12 months. Scenario 2. Rent jumps by £300, you can challenge it through the statutory process and tribunal. Scenario 3, you want to move out early, you can leave with 2 months notice, no penalties. Scenario 4, repairs ignored, you can escalate to the ombudsman once the system is live. These are real protections with real consequences. The Renters' Rights Act 2025 isn't just a law, it's a reset. A new era for renting in England. If you found this breakdown helpful, hit like, subscribe, and tell me in the comments which part of the act you want a deep dive on next. Until next time, stay informed, stay empowered, and stay protected.